All right, welcome back. Last one for this week. So when we left off, we talked about regulations. We talked about the ways in which the rulemaking power can be delegated to an administrative entity, right, as opposed to, say, a tribunal, which can have decision-making power. You can have the same thing going on with rulemaking instead of adjudicative authority. And that's by virtue of an enabling statute against. There has to be a law that gives the power to the administrative body to enact rules. Otherwise, it doesn't have it because it doesn't have, as we said, quote, inherent jurisdiction. Once you have that, right, the administrative body can enact rules, and these rules have force of law, quote unquote, in the sense that they can be reviewed by a court for the same issues that you'd otherwise see with regular laws, such as whether or not the body had the authority to enact these rules, whether it acted within its jurisdiction, whether the rules are constitutionally permissible, and all that. One thing we didn't mention is that because the rules are enacted pursuant to an enabling statute, of course, generally, if you remove the enabling statute, which is what we call abrogation, right? So you get rid of it, which is by virtue of a vote, right? Opposite thing is when you pass the law, then that would abrogate the regulations which are enacted pursuant to the statute as well, which just makes sense, right? That's where the authority comes from, not just the authority to adopt them, but subsequently their legal authority comes from the enabling statute. If the enabling statute disappears, regulations no longer have force of law because they no longer exist under a source that gives them legal authority. So there are grounds of review, I'm at page 154, which are reiterated there, right? Same thing that we said. Generally, first there's a presumption of validity, right, which is phrased as something new, which it's not really. It's true for all laws, right? If you want to say that it's invalid, you have the burden to prove that. You don't show up to court and say, I think this law is invalid, and then the other party has to show that it's valid. It doesn't work that way, right? Instead, you have the burden to show what you allege, which is that the law is invalid. Whether that's on constitutional grounds, charter grounds, procedural grounds, whatever it is, right? So that's what they call a presumption of validity, but again, that's not a separate new thing. The two main grounds of review, and again reiterating that all that happens upon judicial review generally. So you'll have a bylaw, whatever it is, a regulation that's adopted, and then someone wants to say it was done wrong. They go to court and they seek judicial review of the bylaw or the regulation, whatever it is, and then the court has the power to, right, find it unreasonable or incorrect, depending on the standard which is going to apply. So all that happens upon judicial review, and these are all grounds of judicial review. So you can have an administrative decision reviewed on its content, to put it that way. So tribunals say, issues a decision. You can have that reviewed based on correctness or reasonableness. Some of the grounds of review, because ultimately that's what this is, right? The power of the body to enact the legislation, the regulation, that if you're saying it has no power, you assert that upon judicial review. And if the court agrees with you, it is reviewing judicially that action. The two main grounds are, first, the compliance with the enabling statute, which again is just another way to rephrase what we said. So you have to have the requisite authority by virtue of the enabling statute. So the enabling statute has to say this person has a right to whatever it is, right? Issue licenses, pass bylaws, make decisions, whatever it is, right? They have to have the authority by virtue of the enabling statute. Sometimes, often actually, the enabling statute is going to provide for certain things, then these things have to be met. The two main examples are procedural rules. So it's going to say you have to have this kind of majority, you have to have these kinds of people meeting to adopt the statute, for instance, the regulation, for instance, right? Then, if that's not met, you're seeking judicial review on the basis of compliance with the enabling statute, which provides for these procedural rules. Another thing that the enabling statute generally provides for, right, are certain things that might have to be considered in the application of a regulation or of a statute. So say you have a statute that says this guy has the power, as in my earlier example, to approve pipelines. The statute might, and often will say, in making that decision, the person will have to consider A, B, C, and D. Then, if the person does not consider those, again, you're seeking judicial review on the basis of compliance with the enabling statute, because the enabling statute gives the power and also the responsibilities of the person who is making that decision, and they have to exercise that power in a way that's compliant with the enabling statute, of course. Same thing we said earlier is reiterated, page 155. If the enabling statute is found to be unconstitutional, again in whole or in part, whether it's a statute or a section of the statute, of course the regulations will also be invalid if they are enacted pursuant to that provision or that statute. Same thing as abrogation. If the legislature gets rid of it, right, the regulations no longer have the legal basis to flow from. Same thing if it's unconstitutional, right? If it's unconstitutional, it's struck down, assuming it's by a court. And then, right, again, the regulations, for the same reason, don't have any legal authority that flows to them, and therefore they are also invalid. There are highly confusing assertions on the reasonableness, quote unquote, of passing a bylaw. Generally, we do not assess the validity of a rule, again enacted pursuant to delegated rulemaking power, on its substance the way we otherwise would. And this is confusing, but at the end of the day, it's obvious. If you have, we had a bunch of examples so far. So let's put that aside for now. We have these other examples that we use. So someone issues a license. That's a decision, and that decision can be reviewed on its substance. So say the guy says you're not getting a license because you're blind. Then you can assess the decision on its substance. Its substance is because you're blind. That's the justification that's provided by the decision maker. You can have that reviewed, and you can say this is not reasonable. It is not reasonable to come to that conclusion because the guy is not blind, for instance, whatever it is, right? Or because the rules don't provide for that, therefore it's incorrect. Reviewing it on its substance. Akin to a court, right? A court issues a thing called a judgment when it makes a decision, and that explains why it made that decision. Administrative decision makers do that, and often that's what you review upon judicial review, right? If it's unreasonable, it's because it doesn't make sense. It is not reasonable to take whatever ingredients they took, put it through the judgment, and come to the conclusion that's in the judgment. Again, the substance of the decision. The decision reached, the justification for it, and you look at the justification for it and see if it's, right, coherent. If you're claiming that that a rule, back to my example, my main example, a rule is not adopted in a way that's compliant with the enabling statute, you're not looking at the substance of the rule, because it's not a decision, really, right? It's not adjudicative power that you're evaluating. It is the enactment of a rules on procedural grounds. And if you do that, right, or jurisdictional grounds, and if you do that, you look at whether or not it meets the criteria. So the statute's going to say you have to have these people vote. And here's how it happens. You look at whether that happened. Or the statute's going to say the body has the power to enact rules on this topic. And then you look at whether it's on this topic or not. Then you don't look at the substance of the decision. So you don't look at whether it's a good rule, a bad rule, whether it was reasonable, quote unquote, which is a misuse of the word, to enact that rule. Because it's not reviewable on its substance. It's not an administrative decision. And because the body, whatever it is, has democratic legitimacy at the end of the day in some way, right? Generally, you don't review it on its substance. As we said, for historical reasons, and as this is reiterated at page 161, sometimes you can review the substance, which is often a way to indirectly do what you couldn't do before the charter. So if discretion, that's the example I gave last lecture, I think, if discretion is exercised in a way that's discriminatory, it used to be what we call an abuse of discretion, which was reviewing kind of the substance of a decision, even though it's discretionary. And that would be a traditional decision, unlike the example we just gave on adopting bylaws. On adopting bylaws, you could kind of do the same thing if the rule was discriminatory on its face as adopted. And that was mainly helpful when you didn't have the charter and therefore did not have a protection for or against discrimination. It can remain helpful in very limited circumstances where the charter is not going to apply, but that's not something that we'll get into. Generally, the statute prevails, of course, because it is prevalent, right? The statute prevails because it's on top. The regulations are enacted, or the power is exercised, pursuant to the delegation of authority by statute. Therefore, the statute prevails. So the regulations, for instance, can't contradict the statute, or the purpose of the statute, which is what is generally what people generally seek judicial review on. So if the statute is trying to achieve a goal, right, whatever it is, limiting compensation, and you're doing the opposite, then you can seek judicial review because it's not consistent with the purpose of the statute. And again, all that is obvious because the statute prevails. The regulations, the power, whatever it is, only exists because it is granted by virtue of the statute. Therefore, of course, the statute prevails, because that's where the authority comes from in the first place. You can still have, this is mentioned at page 165, a provision to the opposite effect. So you can have a provision that says, we hereby allow this administrative decision maker to override our statutory objective. And then it would be allowed. But as you can imagine, right, that's rare because first, it most often doesn't make any sense, and second, because usually the people who pass laws, right, are happy to delegate the power when it removes work from them, but not when it removes power from them to eventually, right, observe and be able to override what the administrative decision body, is going to do in using that power. There's a short discussion at the end of what we call guidelines. Generally, guidelines are not like regulations. And I gave that example earlier. It's not that important, so if it wasn't clear, you don't have to freak out about it. But sometimes you'll have, right, say, an internal office document, which is a guideline. Even if the authority to adopt it flows from, right, some statute or regulation, it's not itself a statute or regulation in the sense that you can't seek judicial review of it before a court. And that's because it's not of general application. And that's just the general criterion for a law, right? How do we know something's a law? It's general. It doesn't say, right, Mr. X cannot kill his wife. It just says people can't kill other people. It's more general, of general applicability, therefore it counts as a law. There's a different situation where you have guidelines, and that is where you have discretion. So you have discretionary power by virtue of the statute, which we said in the previous capsule is not infinite, right? It can't be exercised discriminatorily. It can't be exercised in a way that's somehow unfair. And it can't be exercised in a way that denies procedural fairness, among many other things. Something that administrative entities often do is promulgate their own guidelines to explain how they will exercise their discretion. So say you give a power to an entity to exercise antitrust power. So the statute says you are hereby granted all of this power to break up companies, whatever it implies. And that power is discretionary to the extent that you're convinced that it's not in the best interest of Canada not to break up the company. In practice, what that will do is it will scare a lot of people, right? Because that power can be exercised in many ways. The people who have businesses don't like uncertainty, so they won't show up in Canada because they don't know if they'll be broken up by the government anytime. So what the antitrust regulator might do is pass a guideline, publish a document on its website that says, these are the criteria we will consider. That does not have force of law. Therefore, it's not binding upon the decision, the administrative entity or the person. So no one can go to court and say this wasn't considered because it was just sent out voluntarily, right? And it does not have its authority, and that's the reason for it, right? Does not have its authority flow from a statute. Because the statute just says the guy can do whatever he wants and break up companies. It doesn't say we hereby give or require that, right? Give the power to or require that the guy promulgate criteria. He just does it voluntarily. Per the statute, right, it's fully discretionary. So the guidelines have no legal value for the same reason we emphasized so far, because they do not flow from a statute. Guidelines have to have their authority flow from somewhere. When they don't, they're guidelines. When they do, they're regulations, right? Essentially, to use the terms in simpler ways. And so you can't go to court and say these criteria are invalid because they do not have force of law, general applicability necessarily, and all of that. There's a slight exception to that, which we'll see so far, which is what we call the doctrine of reasonable expectations in administrative law, which is kind of like, right, constitutional conventions. So when someone does something for a long period of time, it can create an expectation on the part of the regulated, of the people, that that will be done in the future. And then sometimes, and emphasis on the sometimes, they can claim that in court. So they can say, right, we've had these antitrust guidelines for 10 years now. We've adjusted our conduct accordingly, and therefore we want to bar the decision maker from exercising their antitrust power differently. And sometimes, if it falls within that exception, which we'll see in more detail, it might work, but that would be the exception, not the rule. And we'll stop there.